Recognizing a quorum of the commissioners, I call the August 25th, 2026 meeting of the Cannabis Control Commission to order. This meeting is being held hybrid pursuant to Chapter 2 of the Acts of 2025 and is being recorded. Commissioners Delevato, Wilson, and myself are participating in today's meeting. Before I turn it over, I'd like to note for the public, commissioners will be listening to testimony from the public on Chapter 65 of the Acts of 2026, testing regulations and protocols. As this is a public hearing, no quorum is required of the commissioners. If there are any connectivity issues or power outages, the executive director and staff may continue to accept remote testimony or ask that additional comments be submitted in writing. With that, I will now turn it over to Director of Government Affairs and Policy, Matt Giancola. Matt.
Thank you, Mr. Chair. During this hearing, we will hear testimony only on Chapter 65 of the Acts of 2026, testing regulations and protocols contained within 935 CMR 500 and 935 CMR 501. These are available on our website, linked on today's calendar event, and where you normally access Commission regulations. Before we begin hearing testimony, I'd like to remind everyone that this hearing is being streamed live and there are microphones placed throughout the room. For that reason, we ask that you please keep side conversations and noise to a minimum. This will help ensure those watching remotely, as well as those here in the room, can clearly hear the speakers at the podium. Next slide, please. In addition to the verbal comments offered today, the Commission is also accepting written comments on these regulations. Those wishing to submit written testimony should email their comments to commission@cccmass.com with the subject line testing by 5 p.m. today, August 25th, 2026. Next slide, please. Now, some housekeeping guidelines for speakers. In order to allow as many people as possible to testify, we will be limiting testimony to 3 minutes. We ask that everyone providing testimony use respectful language, and the Commission asks that speakers use respectful language and speak to the topic of the Commission's testing regulations and protocols. The Commission encourages speakers to submit their testimony in writing as well. For those wishing to testify who have not signed up in advance, please add your name on the sign-up sheet in the back of the room. First, we will hear testimony from individuals who signed up in advance of the hearing, followed by those who signed up to testify today. Once in-person testimony has concluded, we will begin hearing virtual testimony. If there are elected officials who wish to testify, they may go first. And when your name is called, speakers are invited to come to the podium at the front of the room, introduce themselves and what entity or organization that you represent. For those testifying virtually, when you hear your name called, speakers are invited to come off mute, turn their camera on, introduce themselves and what entity or organization that they represent as well. We will need a short 10-minute break for tech setup prior to the virtual portion of the meeting. Please note that commissioners may take notes during testimony, may ask clarifying questions, and once that testimony is provided by the individual speakers, they'll be reading the written comments that are submitted. I will ask that after hearing testimony, if a commissioner has a clarifying question, they raise their hand to alert me. For those who cannot attend this public meeting in person, written testimony regarding the regulations and the protocols may be submitted to commission@cccmass.com with the subject line testing by 5 p.m. today. I'll call the individuals in the order that they signed up to testify. If someone's not present when their name is called, I'll call the name again at the end of the list. And just for those testifying at the podium in person, I do have this light here. When it turns red, that is 3 minutes. You're welcome to finish your sentence, but in fairness, we do ask that everyone keep it to that 3 minutes. So with that, let me pull up the list. The first individual to testify is Megan Dobro.
Thank you all so much for hosting this session. My name is Megan Dobro. I'm the co-founder and CEO of Safetiva Labs, an ITL in Westfield, and I'm a molecular biologist by training. I so appreciate that you all immediately prioritize testing reform. We've been operating with a vague set of regulations, and it's been long overdue for an overhaul. The Commission has made some incremental steps, but functionally, the problems have not gotten better. The labs with the highest THC numbers are still dominating the market, and the consumers aren't getting what the label promises. Every lab is doing their own thing with little guidance. We have so many questions that have gone unanswered. I believe you have a very capable staff, and they have been working hard to understand the issues with testing and make recommendations for change. And I appreciate that this is a complicated regulatory process. But every month that goes by without meaningful reform is another month in which the market rewards companies for cutting corners, while companies trying to do the correct thing struggle to survive. And ultimately, consumers pay the price. Testing needs to mean something. Otherwise, consumers won't trust the products from dispensaries and the legal market collapses. I've supplemented this testimony with a letter outlining my comprehensive thoughts and recommendations. To summarize, we need lab standardization, clear regulations that leave no room for interpretation, oversight and accountability for companies that prioritize profits over ethics, updated action limits, relaxed security restrictions, and regular and thorough monitoring of products on the shelves. We have a fundamental problem. If labs are punished by the market for publishing honest results, the system is selecting against integrity. You'll be left with no honest lab standing. After explaining to a former commissioner how a dishonest lab could get high THC numbers and keep a clean record, they asked what was stopping me from participating in the same practices. My answer was nothing except my own morals. But I don't think our regulatory system should depend on that. We need rules that make scientific integrity the economically rational choice. We need clear standards for how testing is performed and interpreted. We need meaningful oversight when labs depart from those standards. We need to incentivize cultivators to submit representative samples, and we need to make sure consumers can trust the numbers on a label. The recent audit was a step in the right direction, but let's reframe the findings. The retest samples went back to the same lab that issued the original COA. So the fact that 1 in 5 samples failed to meet the acceptable criteria and that they were up to 55% under the labeled THC amount is only half the story. It's just the floor of the problem. The study was never built to catch lab inflation. So the problem is much worse. I hope you'll include expertise of cannabis scientists and the labs that want to do the right thing when outlining the changes. It'll be important to consider the day-to-day experience on the ground. We have an opportunity to make Massachusetts the gold standard, and I hope we can all work collaboratively to get there. Thank you.
Thank you.
Thank you, Meg.
Any questions?
Yeah, where'd you get that?
This is ours.
You walk-off music, like Academy Awards? That's okay. Thanks, Matt.
Okay. All right. Next up is Ryan Picard.
Morning, Ryan Picard from Analytics Labs. I'm the CSO and oversee our operations in Connecticut as well as Massachusetts. Good morning, Chair and Commissioners. Thank you for the opportunity to speak today. We are here as independent scientific experts and partners to the Massachusetts regulated cannabis industry. Our aim is simple: to help the Commission craft cannabis testing that is scientifically rigorous, commercially fair, transparent, and centered on consumer protection. We believe many of the challenges facing the Massachusetts legal cannabis market are driven in significant part by regulations that can be vague, inconsistent, and contradictory. When requirements are unclear, laboratories can interpret them differently. That creates uncertainty for operators, inconsistent results for consumers, and an uneven playing field for laboratories that invest in rigorous compliance. We are not here to simply identify problems. We are here to offer our expertise and to partner with the Commission on solutions. We serve operators, consumers, state officials, laboratories, and all stakeholders who depend on a credible Massachusetts cannabis market. We urge the Commission to tap into that expertise. Specifically, we ask the Commission to prioritize 3 critical reforms. First is standardization. Establish uniform minimum standards for testing, sampling, method validation, and quality control so that comparable products are tested in comparable ways. Second is microbial limits. Review microbial action limits and testing methodologies using current scientific knowledge and risk-based standards, with the goal of protecting consumers while ensuring that requirements are scientifically defensible. Third is potency manipulation. Implement safeguards against THC inflation and analytical practices that can artificially increase reported potency. Consumers and businesses deserve results that reflect the product, not the laboratory or methodology selected to produce a preferred result. Independent testing laboratories are not simply service providers. They are an essential part of the Commonwealth's public health and compliance infrastructure. For that system to work, laboratories need clear scientific standards. Businesses need confidence that the same products will receive comparable results across licensed laboratories, and regulators need reliable data that they can act upon. Reform must be accompanied by consistent oversight and enforcement. Laboratories that invest in quality systems, scientific rigor, and compliance should not be disadvantaged by those willing to cut corners. Clear rules must be paired with meaningful oversight, usable regulatory data, and timely enforcement. Massachusetts has an opportunity to do more than address existing problems. It has an opportunity to establish a national gold standard for cannabis laboratory testing and for an effective, trustworthy, regulated cannabis marketplace. We stand ready to serve the Commission as a scientific resource and partner. We respectfully urge you to engage with our expertise to standardize and build a framework that earns the confidence of consumers, businesses, regulators, and the scientific community. Thank you for your time.
Thank you very much.
Any questions?
Does that have a volume by any chance?
Next up, we have James Brunel. Okay. We can come back to him if he does. Next, we have Jonathan Ferguson.
Morning, Commissioners, Executive Director. Thanks so much for having us here today. My name is Jonathan Ferguson. I am the CEO and co-founder of Green Valley Analytics, or an ITL in Holyoke. I want to leave you with one clear message. Don't start over. The labs have already done a lot of work. Last year, at the Commission's request, the ITLs came together and submitted recommendations on how to improve cannabis testing in the state. We're all competitors, so getting us all to get into one room and come to an agreement, not really an easy thing to do. But we found common ground and found something that everybody could agree on. We gave the Commission a list of areas where we believed the rules could be clearer, more consistent, and more scientifically sound. That work should be the starting point. From there, I think the Commission needs to do, two things. First, bring in the right experts. Labs know testing really well. We know what works in practice, where the rules are unclear, and where different labs are interpreting things differently. But we're not public health experts. If the Commission is deciding on what organisms are dangerous and what limits are appropriate, or what level of risk is acceptable, those decisions should involve epidemiologists, toxicologists, public health experts, physicians, and other qualified experts. Then bring that science back to the labs and ask, how do we test for this in a way that is accurate, consistent, and practical? Second, think about what happens after a rule is passed. A change may sound good on paper, but it can create problems somewhere else. It can affect growers, it can affect manufacturers, it can increase remediation, increase costs, it can overwhelm labs' capacity, it can even change behavior in ways nobody intended. So before making a change, we need to ask two simple questions. Is it supported by the science? And what will actually happen when we implement it? And what we want out of this process is simple. Clear rules, consistent testing, less interpretation, and better science. The labs have already done the first round of work. Please use it. Bring it to the right experts and turn these good recommendations that already exist into actual policy. Thanks for your time.
Thank you.
And next up, we will have Matt Allen.
Commissioners, Executive Director and staff, thanks for pulling this together today. My name is Matt Allen. I'm a board member of the Sun-Grown Cannabis Alliance and a member of the Mass Cannabis Coalition. We're excited about this new commission that seems to have the executive leadership experience, economic development, and business experience to really get things done. And it's good because, as you know, there's a lot of work to do. At the Sun-Grown Cannabis Alliance, we advocate for policies and regulations that will work for outdoor growers. But we're not just here to support our own farms. We're interested in promoting agriculture across the state. And in the medium term and the long term, ensuring that cultivation in Massachusetts can survive against competition from other states that we will someday see. So one of the things we've been focused on is the microbial regulations, which just don't make any sense to us. I grew up in Coleraine, it's kind of near Greenfield, and you were surrounded by apple orchards. People come out, pick their apples, make their apple pies in the fall. And those apples couldn't pass the microbial thresholds that we face just because of natural levels of yeast and mold and other bacteria. So we are looking for something similar to the New York regulations that have no action levels for total yeast and mold and total aerobic bacteria. They are reportable, but they do species-specific testing for Aspergillus, which is one of the dangerous molds out there. Another thing that we're concerned about is that it's well past time for revision to the soil and water testing. The soil testing, a full-size outdoor farm could face $100,000 a year in soil testing fees. And this money doesn't even go to our colleagues in the cannabis industry. We're going to use another set of labs for that. But no one knows why we're doing this. We've talked to commission staff in the past that weren't sure why. Because we test the cannabis for pesticides and heavy metals. So then why are we going back and testing the same dirt year after year for pesticides and heavy metals? And the water testing also doesn't really make any sense. If it's a non-public water source, you got to test for microbes. But then many organic farmers are adding beneficial microbes to the plant in order to fight yeast and mold, and then we test for microbes down the line. So we're actually pushing outdoor farmers to use to deplete public water sources instead of just use rainwater or a spring or a stream. So these are some of the issues we're up against. Look forward to working with you guys to put in place regulations that work for the industry and or they're based in a real sound public health or public safety concern. So thank you. Look forward to working with you.
Thank you.
Thank you very much. Next up, we have Ryan Dominguez.
Hello, Chair, Commissioners, staff, Ryan Dominguez, Massachusetts Cannabis Coalition. I appreciate you calling this public hearing to get feedback from the industry on the issue of testing. I submitted my letter this morning on some of the MCC specific concerns and recommendations, so I'll keep my remarks on a high level. Our message today is straightforward. Massachusetts needs to modernize its cannabis testing program based on the latest cannabis science and data. For some historical context, our testing protocols and guidance documents were last revised in 2021. That's 5 years of new research and findings on cannabis safety. In those 5 years, Colorado has added at least 4 major testing overhauls and continues making edits on an annual and semi-annual basis. New York, whose program is a lot younger than ours, has made at least 3 major testing changes, with even more incrementally. Here in Mass, we just passed 2 cannabis omnibus bills in the legislature in those 5 years, and you know how long and arduous that process is. Yet, our testing regulations, protocols, and guidance have stayed the same. Mind you, all of these testing regs were created before we had much data on cannabis, before many of these other state testing programs got off the ground, and before we created industry standards. And every year, the industry has come here with the same recommendations in public hearings, meetings, and red tape committees. Cultivators and testing labs alike have been working together to try to find a solution that protects consumer safety while ensuring that we have a viable industry. So here we are again, but this time I understand that you all have a new legislative mandate for the bill we just passed as an industry. And so just for a quick refresher for everybody, Section 35 of Chapter 65 notes regulations and testing protocols shall be reviewed by the Commission at least once every 2 years to ensure that such regulations and testing protocols are consistent with the most recently published industry standards and best practices. And in reviewing a regulation or testing protocol pursuant to this subsection, the Commission shall hold a public hearing, which we're doing today. And the Commission shall report on the results of a review undertaken pursuant to this section, which shall include but not be limited to a summary of findings under the review and a summary of testimony given at the public hearing. The reports shall be posted online. Hard stop. So I understand that nowhere in that legislation mandate, you're required to update or change the testing regulations. And just to be clear, we as the industry did go to the legislature with our original bill language that did explicitly require you to change testing regs based on the science and data, because that's what we've been asking for many years and many iterations of the commission. And so with that understanding, I'm coming on behalf of the industry, hat in hand, asking you to use your power as regulators to not just post the testimony and hearing feedback online. We need real changes to the testing program. And if and when we get rescheduling, the available science, research, and data will only increase, and we need to keep up with that. And I'll end by saying that we need standardization across labs. We need to update our compliance requirements, and we need to do all of this while keeping costs in mind and ensuring that you all lean on the scientific expertise of the PhDs, scientists, and biologists in the room and in the industry. Thank you.
Thank you.
Thank you. All right, next up, we have Chris Adela.
Good morning, Chair Harding, members of the Commission, and Executive Director Ahern. My name is Dr. Christopher Hudal, and I'm the founder and Chief Scientific Officer of Proverty Laboratories. While I want to echo all the previous speakers, because I believe in everything that's been said so far, I'm here to offer some more specific comments regarding microbial testing. Massachusetts General Law, Chapter 94, Section 15A1, directs the Commission to establish requirements for independent testing, including protocols for cannabis sampling, testing, and analysis. The statute further directs that these regulations are to be based on standards issued by the United States Pharmacopoeia, the USP. Implementing applicable USP guidelines would not only fulfill that statutory direction, but promote greater consistency among laboratories and fair outcomes for Massachusetts licensees. First, we recommend the Commission ensure that microbial enumeration methods are consistent with USP guidance. For total count microbial testing, including total yeast and mold, the relevant standard is USP General Chapter 61, the microbiological examination of non-sterile products. That guidance relies on culture-based or plate-based methods which measure viable microbial growth and reports colony-forming units. PCR plays an important role in targeted species-specific identification, such as E. coli and Salmonella, Aspergillus. However, PCR does not measure viable microbial growth in the same manner as culture-based enumeration methods. This distinction matters because culture-based and PCR methods can produce materially different results for the same product. Allowing non-comparable methods has contributed to inconsistency among laboratories, uncertainty for licensees, and reduced confidence that the microbial action limits are being applied uniformly. This disparity in methodologies is also a significant factor in the laboratory shopping issues that have taken hold here in Massachusetts. For total microbial enumeration, PCR should not be accepted as an alternative to USP culture-based methods until the Commission has reviewed and approved validation data demonstrating equivalency for cannabis as a matrix. Second, we recommend that the Commission review an interpretation of the microbial action limits. The Commission's current interpretation is twice as stringent as the relative USP guidance. For total yeast and mold and flour, for example, Massachusetts currently enforces a limit of 10,000 CFU per gram, while the USP-based recommendations is twice that at 20,000 CFU per gram. Based on a review of a 2025 metric data set, approximately 13% of the microbial failures under the current enforced limit would have passed under the 20,000 CFU USP recommended limit. Considering batch size and estimated market value, that difference represents around $13 million worth of failed cannabis flower under the more stringent interpretation. Each microbial failure requires retesting, remediation, and/or repurposing of that flower batch. These steps impose significant cost, delay, and operational burden on the licensees. Applying the USP-based limit will prevent a meaningful share of these failures, along with the associated delays and expense. I request that the Commission, as they implement the new testing regulations, considered following the USP guidance directed to with Chapter 94G. Thank you.
Thank you. Okay, that's all I have for in-person signups. Is there anyone else here wishing to testify in person? Seeing none, I think we're going to take a 10-minute break just to transition to those doing virtual testimony. Maybe 5 minutes. Thanks all. Okay, returning to the hearing.
Oh,
Our first virtual, excuse me, everyone.
All right, we're gonna get rolling here, folks. Shh. Thank you.
Thank you all. So our first virtual hearing participant offering testimony is Michael Marinaro.
Hello, Commission. Hello, Chair and members of the Commission. My name is Michael Marinaro. I'm the owner of Bada Bloom and Bada Brew. I appreciate you hearing me today on the testing regulations and protocols. I first want to say that, cannabis has been legal now since 2016, so we're 10 years into it here. And one of the things that I've been talking about for many years here with testing protocols that I did not see in the changes of the regulations is when companies are using radiation remediation techniques. I would love to see our packaging that would that would correlate to their testing regulations that they are using this. We see it in metric, and we really want to make sure that consumers are aware of what they are purchasing. And we have all the testing regulations where people are having our high THC. I do appreciate the commission that recently did some of their testing to show companies that were not in compliance. But if we actually look at that sheet and see all of the people that were in the green in compliance, the majority of those companies do have radiation remediation machines, and that product was probably run through a rat source machine. So I really think we need to dive into this a little bit deeper. And if we really could be labeling packaging with that, I think it would fix a lot of the issues with testing to show that what consumers are buying, make them aware so they actually know the practices that these products are going through. I'm actually in a facility right now, and we grow in soil. We are waiting our final inspection. We just passed all of our tests. I've been told I'm a social equity applicant. I've been working on my cultivation, manufacturing, and home delivery facility for over 5 years now. And since day one, I've been told by these large corporations that I'll never pass soil testing. You can't grow in soil. Our testing is too stringent. I do not believe that. We just passed our soil test. So, we know companies are lab shopping. We are very well aware of that. 30, 40% THC, even correlating that to the effect of cannabis is not correct. Having high THC in products and labeling it as such, just so they can get more money for their product as they drop the price across the country and here in Massachusetts to knock out small businesses, is not really the correct way. So how do we go in front of that and show that, we are making sure consumers are actually safe? Maybe we label the product because the majority of these large corporations are remediating their products. So soil growing facility here, no remediation on our products, pass tests with flying colors. So this is the way that I grow my cannabis. Corporations want to grow the way that they want to grow, but I think that this is one of the best ways that we can protect consumers and let them understand what they're actually purchasing and buying. So again, I thank the commission for having me today. If there's any questions about this or any other insight, I'm free to meet up and talk more in depth about this. But I appreciate you hearing my testimony today.
Thank you very much. Love the name, by the way, Bada Bloom.
Thank you. Thank you.
And congrats on passing your soil test.
I appreciate that.
Yeah.
Thank you very much. Next up, we have Grant Ellis.
Hello, Commissioners. Thank you very much for taking the time today. My name is Grant Smith Ellis. I wear a lot of hats, but I'm probably one of the few people who speak to you today who has zero fiduciary interest in the outcome of this process, and I think that matters. So let me begin by saying there's no discipline more so than even economics as rife with conflicts of interest as the testing of adult and medical use products for microbial contamination, heavy metals, molds, pesticides, and THC potency. But I'd like to remind you that THC potency is a consumer protection issue and perhaps an antitrust issue under the Sherman Antitrust Act of 1891, whereas total yeast and mold, heavy metals, and pesticides in cannabis are a public health issue that have, in this state, caused deaths at a licensed, regulated operator. I'd like to give you a hypothetical. For example, hypothetically, let's say there was an individual, hypothetically, who worked at an unlicensed lab in the Commonwealth that was extracting THCP from products that came down from Maine illegally and then testing it on their staff who were registered agents with the commission. And let's say it caused those staff members to be incapacitated for days. And then that person went on to, I don't know, become the director of testing at the commission. That would be a serious conflict of interest that would undermine the integrity of the ability to implement valid and legitimate and effective regulations in this area. Let me continue. Moving to the three types of testing and how they can be manipulated. You have three types of testing in this area: plating, qPCR microarray hybridization methodologies, and PCR methodologies. Plating can be manipulated by only running the inoculation for 48 hours instead of 60 to 72 hours. You'll get false negatives on total yeast and mold and other contaminants. 48 hours is good enough for food. With plating, it's not good enough for cannabis. With qPCR microarray hybridization methodologies, there's a black box process. You rent the machine from the company, you put the sample in it, you send the results out to the company. It does this like thing in a black box, it sends you back the results. The fail rate in those is very low, artificially so. PCR can also be manipulated because the different testing kits have different inclusion and exclusion lists. So one PCR may be passing, but it's passing because it's not testing for the most important total yeasts and mold. Also, potency audits aren't enough. I'm sorry. The issue is manipulation of microbial contaminants and dirty product on the market. If we had audited first total yeast and mold, there would be a scandal in this state right now because up to 50% on the market of the product on the market is falsely passed when it's dangerously contaminated with total yeast and mold levels that are higher than is being advertised to patients. Also, please prevent people from selling untested cannabis to children on the Boston Common. Thank you for your time.
Thank you very much. Any questions?
No questions, but a comment. I don't like the insinuation you threw out at the beginning. If you have actual facts you'd like to bring to the commission, please feel free to do so. But, coming in here and throwing a turd in the punch bowl, I do not appreciate that at all. With your hypothetically, that's a pile of horse shit, in my opinion. You got real facts you bring them to the table, period. Not innuendo, not veiled accusations, not appreciated. There's my comment.
Thank you, Chair. Next up, we have Eric Robbins.
Hi there. Can everyone see me okay?
Yes.
Fabulous. Let's get started. So hi there, everybody. My name is Eric Robbins. And much like Grant, I do not represent anybody other than the average customer. So I first started purchasing cannabis products from recreational dispensaries in Massachusetts in the year 2021. And at that time, I noticed that every single product I purchased had a very comprehensive label. It showed a cannabinoid panel, which is usually 8 cannabinoids or more, and then total active cannabinoids under that. And then underneath that, there would be a terpene panel with the top 8 terpenes and then total active terpenes underneath that. At that time, these labels were so ubiquitous that I fully assumed they were a legal requirement in the state of Massachusetts, much like nutrition facts on food. But now, these labels have completely disappeared from the shelves, with many labels listing nothing but the product name, THC percentage, and total active cannabinoids. That is absolutely not enough information for consumers to make an informed choice about the product that they're buying. A complete cannabinoid and terpene profile paints a complete picture of what's in each individual product, because a strain name could be nothing more than marketing. And THC percentage is important, granted, but that doesn't paint a complete picture or tell the whole story. So eventually I came to learn that this was never actually a legal requirement. Apparently it was just a marketing trend between those years. But I believe that what was going on during those years was the gold standard in labeling for consumers. And I don't think that that should be a bygone marketing trend from the past. I think the gold standard should be the law. The reason why this is so important is because the potency and effects of each individual product can vary greatly, and these variations are determined by the unique combination of cannabinoids and terpenes in each product. And isn't that why we legalized this in the first place? So that consumers would have the ability to know what's in their product before they buy it, a luxury that your friend on the street corner can't offer you. And different customers are looking for different things. A veteran with PTSD does not want the same product as somebody with a medical card for chronic pain, who does not want the same product as a recreational customer who's just trying to enjoy their Saturday night. So that's why I wanted to come here and present this idea for a more comprehensive label to be the gold standard and to be written into law. Thank you for your time. Comments or questions? And I would also love to volunteer my personal time to this if the commission ever wants help with it.
Thank you, Eric. Any questions or comments from the commissioners?
No, thank you, Eric.
All right, next we have Don Duncan.
Good morning, commissioners, and thank you for the opportunity to testify. My name is Dawn Duncan. I'm a board member of the Sun-Grown Cannabis Alliance. I'm also a social equity program participant, an Indigenous person, and I have a master's in public health from the Harvard School of Public Health. I've been involved in cannabis equity work since the early days of legalization in Massachusetts, and basically wanted to say that the Sun-Grown Cannabis Alliance, and I know you've heard from at least one of our people earlier, we strongly support the commission's decision to take a holistic look at cannabis testing, regulations, and protocols. Outdoor cultivation is fundamentally different from indoor cultivation, and things like yeast, mold, and bacteria are naturally present in the outdoor environment, so that their presence alone does not necessarily mean that cannabis is unsafe. And that's why we believe the testing system should recognize that distinction while obviously continuing to protect public health and consumers. That's not negotiable. I also think this is an equity and environmental justice issue, because outdoor cultivation can provide a lower barrier pathway into the cannabis industry, including for social equity entrepreneurs and smaller farmers. And sun-grown cannabis can be produced using significantly fewer energy and other resources than indoor cultivation. So at a time when Massachusetts is working toward both equity and environmental sustainability, our regulation should support, not unnecessarily disadvantage, responsible outdoor agriculture. You know, we realized when Massachusetts first developed its cannabis regulations, of course, it was understandably adopting an extremely cautious approach. But now we have many years of experience and evidence that weren't available when those first rules were written. So we really do feel it's appropriate to revisit those regulations and determine whether every testing requirement remains necessary, scientifically justified, and proportionate to actual risk. And our members are subject matter experts in outdoor cannabis cultivation. And we hope that the commission will continue to engage directly with outdoor farmers as this review moves forward, so that at future regular.
The clock is frozen as well, so I'm just not sure if it's Dawn or us.
Yeah, I'm not sure. Don, I don't know if you can hear us. You are frozen, but the timer is as well. So your time remains. Don't know if it is on our end, though. We'll take a look at that real quick.
take 5. Mr. Chair, we're gonna take 5.
We will take 5. Good idea.
Okay, reconvening.
Do we have Dawn back? Oh, I see Dawn.
So Don, my apologies for the interruption. It appears that you have about 39 seconds remaining. If you'd like to use your time, please feel free.
Exactly where it cut off.
You had just
so-
been talking about engaging with outdoor farmers. Do you remember that part? Engaging with the outdoor farmers? You had just been speaking about engaging with the outdoor farmers? Yes.
Yeah, so basically, did you, the part about, I talked about how the cannabis regulations were adopted really early, so it's of course appropriate to revisit them now. And we consider our members as subject matter experts in outdoor cultivation. And so we hope that the commission will continue to engage with the outdoor farmers and look forward to working with you in the process. So I was pretty much done, I think, when it got off, hopefully. So
Thank you,
we
Dawn.
thank you for your time and are really glad you're doing this and look forward to working with you guys.
We appreciate you and thanks for bearing with our little technical difficulties. So
Um,
you proved that you're unflappable under pressure. So good for you.
Thank you. Okay.
Thank you very much.
Yeah.
Next up, we have Tim McNamara. I don't believe he is here just yet, so we can come back to him if he does enter the room. Next, we have Jennifer Keeley.
Hello. Good afternoon, members of the commission. I wanted to thank you for the opportunity to speak today. My name is Jennifer Keeley and I am the CFO and Compliance Manager at Root and Bloom. I've worked in several states in the cannabis industry since 2013 and have been involved in many testing work groups over the years. Today, you've heard a lot about what to test for, certain proposed allowable limits, and a bunch of other important suggested changes. But today I am here to discuss my testimony to focus on three things: testing frequency, timing of testing, and testing validation. So let's talk frequency. Currently, flower testing requires cultivators to break down cultivation batches into 15-pound increments for testing. This additional frequency of testing does not add value. It just adds extra tests. If accuracy is the goal, there are better ways to get there. To devise a system that is more representative of the batch, several samples should be pulled from each batch, consolidated into a single representative sample, and then submitted for testing as a single submission. This is done in other states where you pull from several parts of the plant, making sure it's a true representation of the batch exists, where contaminants such as pesticides, heavy metals, and micro could exist. However, this does not work for potency. So to address that, let's talk about timing intervals of the testing. Flower should be tested when additional handling or changes to the batch exist. One example of this conversion of flower is to take it into a pre-roll form or to sell shake as flour. We should forego the 15-pound testing rule and test the batch as a single submission for contaminants and implement potency testing on flower when it is materially changed, such as a pre-roll. This allows for a more precise testing on potency, but does not waste testing on additional contaminant testing that can be identified from the single initial test. Which brings me to my next topic, which is process validation. The Oxford Dictionary defines validate as to demonstrate or support the truth. Validation is common in the pharmaceutical industry and involves a structured, data-driven approach. So how would this work in marijuana, you ask? It's basically the same as gaining trust. To apply this to a practical example, I will tell you a little bit about our cultivation. Our company cultivation license alone submits approximately 200 pesticide tests each month. We have been operating for 4 years. We have never failed a test for pesticides, and that should mean something. It should result in reduced testing on contaminants. There should be an avenue to show that some trust in our process and operation and validation methods. Process validation has been successful in other states where a series of passing results allow you to validate your process. This doesn't mean that you're off the hook. It just means less frequency in testing. It also opens up bandwidth for independent testing labs to test for what really matters, to ensure consumer safety. So again, if we focus on these three things, testing frequency, testing timing, and testing validation, we can provide more accurate results and certainly lean on the industry experts and test when it makes sense, but not test just to test.
Thank you,
Regardless of
Jennifer.
what you take from today's testimonies,
Sorry, that's time.
considering any changes, I encourage you to reach out to the leaders of independent testing laboratories for their guidance. Thank you.
Thank you. Next up, we have Andrea Rabel.
To speak today. My name is Andrea Rabel, and I'm a patient. I rely on cannabis for my survival. I have epilepsy, brain damage, tremor, allergies to yeast and mold. The list goes on. In my experience, contamination in products is the difference between relief and respiratory distress. Accurate labeling is the difference between starting a seizure and stopping one. I don't need to tell Massachusetts that honest and clean markets matter for patient and worker safety too. I've been up and down the East Coast in search of safe, reliable medicine, but instead I found a systemic problem. In New Jersey, it felt like regulators weren't listening. So last year, I started the Safe Leaf Society and released secret shopper results in New Jersey. These results showed that there was widespread potency inflation and microbial contamination on the market. The legislators were able to respond by calling a state assembly committee hearing on cannabis testing. That hearing resulted in the development and introduction of a bipartisan reform bill. A 1291 was built to design a sufficient safety system for less than the cost of a reference lab. Focusing around standards, oversight, transparency, and accountability, many of the proposed changes can be implemented at the regulatory level. This bill calls for testing standards, validation criteria, a public COA database. It requires the oversight of microbiologists and a chemist. You need a secret shopper program, an external audit program, and whistleblower pathways and protections to prevent accusations of conflict.
Looks like we.
Cannabis lab, which we see in across all other industries. Safety oversight is not a luxury, it's a necessity for a functional market and public health. This is a national problem, and when I say there is a problem in Massachusetts, please do not take it personally, but please do take it seriously. Some of the same companies.
Oh my God. I know.
My feelings exactly.
To have future collaborations and conversations if you're interested.
Andrea.
I would just like to point out that question 8 is coming up in November. And it's up to the public to vote, but it's up to you to give them the confidence to save this market. The patients need this, the public needs this, and you have the opportunity to lead the nation and change here. So I'd like to be respectful of your time and say, if you have any questions, if anyone would like to reach out for further conversations, I welcome it. Thank you.
Thanks, Andrea.
Thank you.
I'm sorry, about 10 seconds of your testimony did cut out for those in the room. So I would just encourage you to email your thoughts to the commissioners.
Please
You
do.
Uh,
can submit that at commission@cccmass.com. Thank you again for testifying.
Well, we absolutely got the intent. Thank you, Andrew.
Okay,
Sorry, before we go,
sure.
Paul, are we good?
Can folks hear us even if our audio is off on there on Zoom?
The live is still on in the room. So yes,
Yeah.
Zoom may not hear you, but the listening audience to the meeting can hear you.
All right, no problem. Next, we have Sherman Horn. Excuse me.
Yeah, they can't hear us. So I think folks on Zoom were instructed not to be on the teams. So
Can you hear us now?
Yes, we can hear you.
Sherman, if you are available, you are next up to testify.
I would like to thank the commission for the opportunity to provide my testimony concerning cannabis testing regulations. I am the Director of Regulatory Affairs at Medicinal Genomics Corporation. Before joining MGC, I was the project manager that started the cannabis testing lab for New Jersey's cannabis program in 2012, and I have been analyzing the cannabis microbial testing rules across all jurisdictions since 2019 until today. I'm a PhD molecular microbiologist with 40 years experience in microbiological methods that spans from plating to qPCR and 15 years experience with cannabis microbial testing regulations. I would like to share some recommendations from our written comment for modifying the rules for microbial testing and related testing issues that may affect test results. First is that Exhibit 6 be amended to replace E. coli pathogenic strains with shiga producing E. coli across all three material categories with an action level of less than 1 colony forming unit per gram. Second is requiring testing to detect the 4 Aspergillus species for unprocessed materials and concentrates which are intended for consumption through the inhalation. Third is that total coliforms and biotolerant gram-negative bacteria be removed as pass-fail criteria under Exhibit 6, and that total yeast and mold and total aerobic bacteria be restructured as follows. For adult use cannabis, TYM and TAB should be retained as monitoring tests only and not pass-fail criteria at an action level of 100,000 CFU per gram. For medical cannabis, TAB should remain a pass-fail criterion at 100,000 coliform units per gram, and TYM a pass-fail criterion of 10,000 colony-forming units. Fourth, that section 4.2.1 and Exhibit 6 be amended to create a subcategory for orally consumed cannabis products, and that S-Tech, Salmonella species, and Listeria monocytogenes testing be required with an action level of less than 1 colony forming unit per gram. Fifth, that Exhibit 6 be amended to create a subcategory for topical and mucosal contact cannabis products, and that Candida albicans, Pseudomonas aeruginosa, and Staphylococcus aureus testing be required with an action level of 1 colony forming units per gram. 6 is to require a certified performance tested method if available. These PTMs have been validated by an independent cannabis testing laboratory. Other methods must be validated using cannabis matrices if AOAC PTMs are not available.
Thank you, Sherman.
Lastly,
Thank you. I'm sorry you are at time, but we would encourage you to submit your comments by email at commission@cccmass.com. Thank you very much.
Thank you.
Next up, we have Peyton Schubert.
Can you all hear me? Yes.
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 Wonderful. Can you see me?
Now we can. Wait, we did.
Okay. Sorry, I'm getting the internet unstable notification. So if at any point I break up, just let me know. But good afternoon, chairs, commissioners, and thank you for holding this hearing. I truly appreciate it. For those of you who do not know me, my name is Peyton Schubert. I'm CEO and founder of Six Bricks, a family-operated dispensary at 1860 Main Street in downtown Springfield. We turn 4 next month, so we've been in the space for a little bit of time. I'm asking you for the same 3 things you've heard from the lab side today: standardize the methods, enforce the standard, and require representative samples. What I can add is why these 3 things matter at the register. Because a retailer standing next to a lab makes an argument that neither of us makes alone, the labs can tell you what is broken in the testing. I can tell you what it costs when a customer stops trusting the label. So let me start there. A customer buys an eighth labeled at 30% THC. They come back the next day and tell me what we sold them was something weak. I have no answer beyond that's what the COA says. I'm defending a number I did not generate, cannot verify, and do not control. That conversation doesn't happen at a lab or at a cultivation site. It happens at my counter. And because I'm the last person in the chain, the consumer actually sees, we carry the weight of that. It gets more expensive than a conversation when a testing result changes after a product is on our shelf. And that is not just a paperwork correction. It looks like an administrative hold and metric. Inventory I've already paid for that freezes in place. Products I've already sold out in the world. And when it escalates to a recall, which we've unfortunately experienced, I'm the one calling customers to tell them that something they bought from us, something that arrived with the passing certificate of analysis is being pulled. And I've made those calls. The lab that issued the certificate is not on them. I am. And that is real money and real reputation. And it lands on the operator with the least control over the results. The last thing I'd ask you to weigh in on is what the label teaches consumers to want. Today, this market runs on a single number, and that number is what consumers walk in asking for, THC. It is also the number the current system gives the most reason to inflate. Terpenes in the full cannabinoid profile tell a customer far more about their experience they will actually have. And my team spends its days redirecting a conversation the label set up, in my opinion, wrong. We should not be building an industry on one data point we have the least confidence in. We need standardization, enforcement, and samples in order for us to be able to progress forward with a more holistic story and one that consumers have faith in. If not, turning to the illicit market is something that many consumers discuss doing at POS due to frustration and paying tax on a product that is not clear enough to them exactly what they're getting. So I thank you for your time in taking this matter seriously.
Thank you, Peyton. Any questions or comments?
Thank you.
Seeing none. Our next and final individual is Tim McNamara. Yes.
Yes, we can.
Thank you to the chair and to the commission for allowing us to speak to you today about testing. I come from a background as an attorney, but I've been doing this for about 10 years. We started a vertical organization here in Cranberry Country in Middleborough. We're not an MSO. I am a social equity member and I have another store. So I have broad experience to bear in this industry, but I come from a background of helping people do business in the state of Massachusetts, period. And so my perspective is that we knew, so I'm also a member of the Sun Growers Alliance with Don, who spoke earlier, and I believe Matt, although I missed his testimony. For a long time, we've been advocating for reasonable requirements related to specifically microbe testing. We spoke to the initial commission about it. We filed a petition. MDAR was involved in some of the testing criteria. Through our petition, we were able to deploy other biocontrols that, in other words, using certain bacteria for the purpose of killing other pests or eliminating other pests from the grow, specifically in the outdoor is where we would use these tools. So, then we also revisited another iteration of the commission at a time when I believe the industry started talking really concretely about how testing needed to change. And that was, in my mind, the entire set of regulations as they were designed prior to anybody, doing any transaction is really, in my mind, a solution looking for a problem, because we were concerned about all of this diversion, and in the end, none of it really happened. And I see the testing regulations as very similar in that respect. And I say that not to ignore concerns of people. I think people have a right to be concerned. They have a right to know what's in their material. But you know, the idea that there's an action level set for total yeast and mold when, you know, every outdoor grow in the Commonwealth is going to fail for that action level, it just doesn't work. I mean, it's an unworkable solution, and you do end up in a remediation situation, which people are also concerned about. The idea that you're testing any plant and that test is going to be representative of every gram of that plant is kind of a fiction. So, you know, what my suggestion, in addition to what Sun Growers Alliance have put forward, is to use the research department within the commission to establish a baseline. Number one, what is the baseline total yeast and mold that we find on an indoor grow, on a greenhouse, and outdoor? Number two, monitor health cases if they occur. There is a testing lab at Brandeis that can handle contaminated drug samples. You can use the DPH lab, but you know, just somebody should be reporting on actual health incidents so that we can understand what it is the danger. You know, where is the danger in this? Because to have these conversations about new labels, this action level or that action level, is useless without data. So that is my main suggestion today.
Thank you, Tim. Appreciate it. Any questions or comments?
Thank you, Tim.
So with that, that concludes today's public hearing. Thank you all for your testimony. And with that, I'll turn this meeting back over to the chair.
Thank you, Matt. Appreciate that. I'm just going back. There were a couple of individuals that were not there. So did James Burnell show up? No, James did not show up. And then let's see, who was the other one we had here? So Tim, we already had Tim. He was at the end. Is that it? Did we have anyone else that was missing there?
That is,
I think that's it. Okay, great. No, very helpful. Want to thank everyone that participated online and in person. It's such an important topic, and you know, the three of us obviously know it's front and center, not just based on the most recent legislation, but you know, if you go back to the five things that I always think about: safety, you know, number one, equitable, efficient, transparent, and sustainable. I mean, it's hitting minimally three of those. Critically important to our industry and ultimately to the patients and the consumers that we serve. So we take it very seriously. Please, as has been stated, submit your thoughts in writing if you have not already. And Matt can repeat the address. I forget it off the top of my head.
Absolutely. It's commission@cccmass.com.
There you go. Commissioners, any other thoughts?
Thank you to everyone who came out and gave testimony. You know, this is, to the chair's point, just double clicking on that, it is incredibly important for us. It's something that we want to and will be remaining as a top priority. And one of the things that I heard today that I'm taking away is this critical importance to standardize, right? Like, we need standardization, and it was not, it couldn't be more clear today. Consistently with every speaker that came on, both virtually and in person. So we have a great team, and as you all know, we are evolving here at the commission, and really looking forward to working together with many of you as we move into the future. So thank you.
Thank you. Commissioner Wilson.
Yeah, so for those who don't know, the commission is standing up a testing working group. It's actually already put together, and we'll start meeting. We were going to incorporate this testimony into the work of that group, and we will also be reaching out to the ITLs and other operators as inputs. So there's active work going on this to modify the regulations, to look at the policy documents that are referenced therein, and to make some of the modifications that we've been discussing in some form or another before those come back out to the public. So you'll be hearing from us. Feel free to reach out, and we will provide updates as that process develops.
Commissioner?
For those that aren't aware, Commissioner Wilson is your point of contact for testing, so feel free to bombard him.
And our email addresses are online. All right, unless there's any other business, ED? No? I will see if there's a motion to adjourn.
So moved.
Second. All right, roll call. Commissioner Delabato?
Aye.
Commissioner Wilson?
Aye.
Chair Harding, aye. We are adjourned. Thank you, everyone.
Thanks.